Good afternoon, and thank you for joining our panel discussion, Technology and Antitrust Competition Policy, Economist Views, and Next Steps After the Whistleblower Hearings. My name is Tom Romanoff. I'm the Director of Technology Policy here at Bipartisan Policy Center. Hope you're enjoying your afternoon. This week, we heard from Frances Hogan on issues related to Facebook. This week's testimonies and revelations add to an ongoing competition and antitrust debate. While Facebook has been the focus of the latest hearings, the ramifications for these discussions go far beyond this one company. Many have asked if this is big tech's big tobacco moment. Hard to say, and I'm not the one to read the tea leaves on that policy. It is clear, though, that big tech is facing some kind of regulation, and some of the companies are calling for it themselves. The question I think people are asking themselves right now is what comes next? The debate is often framed by two camps, the breakup of big tech folks and the let innovation and market address the issues folks. In many ways, this conversation reflects the ongoing debates around government intervention in the market and laissez-faire economics. The middle ground on big tech is currently less defined, which is the goal of BPC's work in this space. We are working to clarify the issues, create common ground for discussions, and recommend evidence-based solutions. Our measured approach is our institutional process and our strength. Today, we are not going to have a definitive answer for you on what should happen next. Instead, we will focus on the economic side of the debate by presenting two leading economists who will discuss their perspectives on competition antitrust in the context of the latest whistleblower testimonies. Today's conversation is a bit different than our usual structure. We did not invite panelists based off of their political party affiliation. Instead, we focused on their body of work as economists. Each represents a moderate approach to the competition conversation and differing views on applying government intervention in the sector. If we were to put this into political terms, they would represent the center left and center right on the issue. Our moderator is an expert on the current debate, Leah Nyland, and was invited to moderate because of her tremendous contributions to the discussion. She represents the very tip of the spear when it comes to covering the ongoing Facebook whistleblower issues. I welcome you to participate in today's discussion by submitting questions using the comment section on the, I'm not saying this ironically, social media platform in which you are viewing this discussion. We will try to get to each question at the end of the conversation today. You can also tweet questions at PPC Live. Now we're over to Leah to introduce our panelists and get the conversation going.
Thanks so much, Tom. As he said, I'm Leah Nyland. I'm Politico's antitrust reporter, and I'm here today with two great antitrust economists, Luigi Zingales of the University of Chicago Booth School of Business, and Carl Shapiro of the Haas School of Business at the University of California, Berkeley. As Tom said, we're going to be talking for about the first 45 minutes. We're going to take audience questions at the end. So please do feel free to submit questions using the live chat on YouTube or on Facebook, or you can send them via Twitter using the hashtag BPC Live. So I'd like to start, Carl and Luigi, just sort of setting the stage for our viewers, sorry, with a couple basic things. Carl, what is the consumer welfare standard, and do you think digital platforms change how we should look at it?
Thanks, Leah. Very happy to be here. So the consumer welfare standard is basically the idea that when we evaluate mergers and company behavior under antitrust, we look to see what the impact is on consumers. The classic case would be a company that improves its product, puts its competitors under great pressure, maybe drives its competitors out of business, but consumers love it, okay? You might think of Amazon as an example. That is generally seen as competition at work, despite the fact that some rivals are driven out of business or put under great pressure. So that focus on the consumer has been really a lodestar, of North Star for antitrust for decades now. To good effect. Before this, back in the 60s especially, antitrust law was rather confused and actually sometimes operated to stifle competition because this was not well understood. So that's where it's coming from. By the way, it's not a very good term because we also look to protect workers, for example, to make sure that they have competitive options in terms of jobs. And so it's not just consumers, it's really, I prefer the term protecting competition rather than consumer welfare standard, but that's the idea. Now, in terms of the digital media and the platforms, it's the same principles still apply. Competition is a process by which companies try to offer better deals to their counterparties, to their trading partners, to consumers in order to attract their business, or to their advertisers in order to attract their business, another set of buyers in social media for advertising supported services. So the same principles apply, but it becomes more difficult because take Facebook or Google, they're free to consumers, to users. And so, so we really need to focus on non-price dimensions in which they compete for users and recognize that their business models involve advertisers. So the same principles apply, but there are some complications.
Feel free to offer anything you want to on the consumer welfare standard, but I wondered if you could explain what a kill zone is, how it relates to M&A policy, and sort of where we are a little bit in the debate around that issue.
Surely. First of all, thank you for the invitation. It's an honor to debate and talk with you and Carl Shapiro. So I, by and large, agree with Carl that protecting and promoting competition is the goal of the antitrust legislation and antitrust enforcement. The question is how broadly you define this, and then certainly not only means providing lower prices and higher quality consumer, but there is also an issue of innovation, which is important, and choice, which is particularly important when it comes to the market for news. So even if we have the cheapest news possible. In fact, on Facebook and Google is for free, not technically for free because you pay with your data, but at least you don't pay any monetary price. But we are concerned also about the diversity of view and the quality of the content and so on and so forth. So I think that the goal is actually, in my view, broader. And when it comes to Killzone is very much related to the issue of innovation. So one of the things that are difficult to measure, but nevertheless are important and should not be ignored, is to what extent the current industry structure promotes or does not promote competition and innovation. And I think that one concern that was raised by many people in the industry, particularly surrounding the digital platforms, is that the power of this platform to acquire nascent competitors very early on really eliminates every potential incentive to enter and so to innovate and to change. And this statement that was repeated also by some important political figures might appear kind of in violation of some basic standard economics. If Facebook or Google acquire you at a high price, why you shouldn't be delighted? Why this is not promoting more innovation? In fact, there's a branch of IO discussing how this might lead to excess entry because you enter just to be acquired, not really to innovate. And in a paper with two co-authors, what we show is a possibility. So it's not a necessity result, but it's a possibility that in a world where the value of the platform is also driven by the expectation, by the number of consumers that are attracted to the platform, and this is driven by the expectation about the long-term survival of the platform, the expectation of early acquisitions is such that makes it easier for incumbent to buy any entrant at a relatively cheap price, really allowing out the incentives to innovate. So I think that the claim that was raised by many venture capitalists, at least is not inconsistent with economic thinking when we think about the world of digital platform. Now, whether this is the dominant case or not the dominant case, etc., I'm not prepared to say, because I think more research is needed. But I think that's what the kill zone is about.
Great. So, Carl, back in 1999, you were the co-author of a book called Information Rules, which has been the basis of a lot of research on digital platforms since then. Yeah. Nice product placement there. I just wanted to know, what has changed in your mind since that you wrote that book? Do you still think like everything you concluded in that holds true today?
Well, the book, which I wrote with Hal Varian, I think because, again, Information Rules, a strategic guide to the network economy, what we were trying to do was lay out for a broad audience of policymakers and business people the economic principles that are central to the information economy, including network effects, which excuse me, matter so much for social media. So I think we are very successful, and that's why the book has been durable, and that those economic principles are durable. As we put it, technology changes, economic laws do not. So I'm proud of that, and that's held up well. At the time, I did a lot of work on antitrust back then as well. The two big companies that were in the target then were Intel and Microsoft, right? The Wintel duopoly, as it was called back then. I actually testified on behalf of the government, the states in the Microsoft case for remedy. So and that Microsoft case, by the way, is the critical court precedent that's going to be affecting, say, the Google and Facebook cases the government's brought now. So very, very important. I would say the principles are durable, like I said. For example, we talked about advertising supported services and so forth. So what's changed is just the immensity of it. When you have Facebook with whatever billion users or whatever it is, we weren't thinking explicitly about that type of scale. And the entrenchment, also the fact that these dominant firms, these big tech companies are so valuable and so hard to displace. I thought back then Microsoft was hard to displace in Windows and Office, and that's remained true, actually. Those are still pretty durable market positions. But we're looking at a scale now beyond what we saw before. That's the main thing. But the principles are valid, and yeah, unfortunately, the examples from the book are now 20 years old. So of course there are tons of examples, but they generally fit. There's 3 chapters on network effects, for example, that are, I think, very informative when we talk about Google, Facebook in particular, because network effects are fundamental to Facebook.
And Luigi, a lot of your other research is also focused on the financial industry and the financial crisis. Do you see parallels sort of between the big banks and the big tech companies?
Oh, absolutely. This has been one of the issues why I decided to get into this area that, unlike Carl, is not my natural area. I'm a financial economist and only interested in IO mostly for policy consideration and policy concerns. And I think that what I see happening in the digital platform world is what happened to the financial industry on steroid. And let me tell you one factoid which I learned sort of studying what led to the financial crisis, which I think is very useful, is in 2004, if I remember correctly, there was a consumer bankruptcy reform. And everybody, not just the Democrats, but also the Republicans, said that everybody was steamrolled by the financial industry, that lobbies always existed, but this time there was one single voice, and this single voice overtook and prevailed in every single place. And so I started to wonder why that was the case, why it was so different in 78 versus in 2004. And the answer is very simple, is that in 2004, the financial industry was much more concentrated and much more homogeneous. So when you have an insurance company fighting against a small bank, fighting against a big bank, then you have space for a legislator to actually understand the various positions. I believe in competition not only in the product market, but also in the political market, in the lobby market. And from competition in the lobby market, you get to see something closer to the truth. And what happened is the homogeneity made it impossible to have legislation that was relatively objective, and was so pro-financial industry that, as I show you in my book, Capital is for the People, ended up backfiring the industry itself. And I think that history seems to repeat itself. In the digital world, we have two monopolies, certainly Facebook and Google, that are so powerful and so influential that they are either blocking legislation or pushing legislation in a direction that I think long-term would be bad, not only for all of us, but also for them.
Great, thank you. So now that we've set the stage a little bit with some of these concepts and where both you guys are coming from, I'd like to talk a little bit about sort of where we're going from here. So one of the big questions I think facing both regulators and sort of Congress right now is how we should be handling big tech. And I wondered if both of you could offer some thoughts about whether it's most appropriate to sort of deal with big tech through antitrust or potential antitrust reform or more sector-specific regulation. Carl, why don't you go first?
Sure. So I think to answer the question, I would encourage everybody to pause and ask, what problem are we trying to solve regarding big tech? So, for example, one problem would be the spread of malinformation and misinformation, let's say through Facebook or YouTube or Twitter or whatever. That's not a competition problem in my view, or not, at least not fundamentally a competition problem. It's something about content moderation, and that points in my direction to solutions that are of the form, maybe modify Section 230 so that we have some liability for actively propagating falsehoods. That's one thing, and I'm not sure that breaking up these companies would help with that problem. That might make for a race to the bottom in terms of this type of malinformation. So if that's the problem, maybe you have a liability regime. If it's a privacy issue and the use of information, maybe you need a regulatory regime. You empower an agency, and of course other parts of the world are doing this, to put in tougher rules to protect consumers' privacy, or to have opt-in or opt-out, I should say, so that the consumers have a more clear choice to protect their information. So then you have a regulatory solution. If the problem is some sort of anti-competitive practice like exclusive dealing or a merger, well, then that's a traditional antitrust competition problem, and that should be dealt with either by antitrust enforcement, or if we think the laws are not adequate, they're too weak, and I've written about how I'm concerned about the courts have become very cramped in terms of their interpretation of the Sherman Act, then you have some antitrust legislation, which in my view would be better if it's across the board. So we're establishing principles that apply to the whole economy, or at least all dominant firms in the economy, and not just big tech. So it depends on what problem you're trying to solve. Most of the problems that I think are getting attention, certainly all the Facebook horrors that we're hearing about, are not fundamentally competition problems. They have to do with content moderation, and so it's not an antitrust solution. It's either a liability or a regulatory solution.
I suppose I should note here that actually Facebook whistleblower Frances Haugen agrees with you, that she thinks the company should not be broken up, because then they wouldn't necessarily have the resources to address some of the misinformation and election integrity issues that they have given rise to. Luigi,
let me just add,
sort of view here?
I think the fundamental problem is Facebook, for example, since they make money by engagement and advertising, it's clear from all this evidence that the desire to make money and compete to get more advertising has led them to have horrible content and horrible practices. So breaking them up would not change that fundamental incentive. It's baked into their business model and their leadership, apparently.
Luigi, what about you? What do you think is the best way to handle big tech?
So first of all, I agree with Carl that one solution does not fit them all. And since big tech is both Amazon and Facebook, and I think that the potential problems are very different and the potential solutions are very different. Where I disagree is on the issue of content moderation and competition. In my view, Facebook is, and all social media, but Facebook in particular, is in two businesses contemporaneously. One is a business of posting that has a gigantic network externalities, because I want to post my picture in the same place where my friends are watching and vice versa. And then there is a there's a business of editorial process, content moderation. So the fact that I might have a website where I post my stuff doesn't mean that my stuff is promoted. I'm old enough to remember in the mid-90s when everybody started to create a website at the university putting their papers, okay? We could post, and ideally if we had a common place to post everything, we would do it because it's easier for others to find us. That part is what I consider a natural monopoly, because there are very strong network externalities. Then there is the editorial content part, where I am pushing the most extreme views in order to keep you attracted to the platform. And this is where, having the choice, I would choose something different. So, for example, when I look at Twitter, I cannot stand people who talk about their personal life or the stuff on sport that they follow, because I actually look at Twitter for news, particularly economic news. So if I had a nerdy editorial system that I pay for a limited amount of money, and they sort out and they take out all the personal stuff and they only put at the top of my news feed I think that would be great. And other people, my son would prefer the opposite. It would like a sort where the sport comes first and the economic news never appear. So I think that a market for editorial services could be developed, as long as the network externality component is a regulated monopoly. So I am in favor of a breakup, but not breakup Facebook from Instagram, a breakup horizontal, where there is the posting component. There should be a regulated monopoly. And then there is the editorial stuff that should be a competitive market. And if you don't want to see awful stuff, you choose a different editors, like we do with newspapers. It's not that newspapers, they're not awful newspapers that publish some crazy stuff. Is that we were not served every morning at breakfast something we didn't like in the past, and now we are.
Yeah, that's interesting, because that's sort of the basis underlying the interoperability bill in the House Judiciary package. The idea being that if it was easier for consumers to move their data and sort of network across to a different one, they could go to a different platform that makes different choices about what information to amplify. So,
but it's more than that. I am a big believer in interoperability, but I don't think that that's enough, because if you allow the organization that does the posting, like Facebook, to integrate vertical and doing also the editorial stuff, they're going to subsidize the editorial stuff with the posting with their monopoly, and so they're going to crowd out every other competition. The reason why today there is no alternative is because it's not only they don't make it easy through obstacle to interoperability, but also is because they are vertically integrated. They subsidize one business with the other, and there is no space for competition on the editorial side.
Okay. I'd like to talk about one of the bills in particular, the Klobuchar-Grassley bill. This is a little bit of a version of the House Judiciary package. It makes a couple tweaks from the one there, but it's very much focused on non-discrimination in their view. But they don't want the big platforms preferencing their own products. They don't want them discriminating against rivals. I'm curious, what are your two thoughts on that? We'll start with you, Carl.
Well, I'm sympathetic with the goals, which is the notion of non-discrimination or equal treatment. I think many people find attractive. We've tried to do this in telecom in some cases. My concern is simply unintended consequences. I'm not sure, well, let me put it this way. It matters a lot. The devil's in the details. My concern is, suppose you have a platform, let's say Apple, and they say they want to improve something. They want to integrate some music more with some other video and with some other information they have. And they want to improve their platform or their product in some way that is a pretty serious threat to some other businesses that are on that platform, whether it's Spotify or Pandora or whatever, just as an example. This may not be the best example, but I'm using it. So as I understand it, as soon as they want to do something like this, they'd have to, I guess, have an interface to work with all the other music companies and treat them equally. And again, that sounds sort of good, but in an innovative world, if you really get into how do products get improved, and integration is the name of the game. I mean, whether it's hardware or software, this has been fundamental to making products better for 25 years at least. How does it work? Do you need pre-approval? What is the core technology versus something that's outside of it where these duties arise? Who do you have to interact with? Everybody? So it's very tricky. So like I said, I'm interested, but I'm concerned that it would cause a lot of damage if not done well. And then it's the federal courts are supposed to sort this out. I'm not too comfortable with that, having testified a lot in court. It just seems like you need an agency that has expertise to do this rather than going to court to decide these, what could be very technical issues in a fast moving business. So again, sympathetic, but wary is my reaction.
Luigi, what about you?
In the detail, but I'm much more sympathetic than Carl. I think that there is a risk of unintended consequences. There is always a risk of unintended consequences by definition, because if they are unintended, you don't know, you don't expect them, so they are always there. So if we start from that principle, we should basically go fast to the laissez-faire, because every form of regulation can have unintended consequence. So I think that in my view, the principle of you cannot be at the same time a player and a referee, even if it's violated in some cases. We know that in local supermarket, you place your own product, but they don't tend to be monopolies. So I think that in platforms, because you learn precisely from Carl Shapiro that in world where there are strong network externality, very often you end up in a winner takes all. I think you are afraid that this platform will use their monopoly power to extend it and gain a foothold in a lot of other businesses. And in policy, you have to trade off different risk. And is there a risk to slow down innovation? Yes, but I think that to me, the risk of ending up in an excessive concentration of power in a few hands is much larger than the risk of slowing down the innovation a bit.
By the way, I don't think these. Look, you said unintended consequences, unforeseen. That's not how I think about it, actually. I think a lot of the consequences are very foreseeable. If one understands the process by which these platforms have evolved and become better, then you can see how this bill could easily disrupt that process. I think there are a bunch of companies who that's what they want, okay, because they don't want to face the competition from the platforms who are naturally trying to expand their empires, okay, and compete in other areas. This is a classic thing. I remember when I was at DOJ in '95, my first time as the chief economist there, Microsoft Windows monopoly, they decided to launch Microsoft Network, which was an online service. And there was a lot of concern of the existing online services that Microsoft would just take over. Well, it didn't happen that way. It was a foray by Microsoft into an adjacent market. Those can be very powerful. And the big tech companies attacking each other can also be very powerful force of competition. And so I'm just concerned about that will be reduced. It's not unforeseen. it's foreseen. I'm telling you, it's going to happen. And I just think this needs to be done in a very careful way. To go back to where I started, if this is a very powerful tool, if Congress wants to change the law in this direction, it's a form of regulation. I just would like more evidence that there's substantial harms that we're solving by doing this. And I don't think that's been shown either.
here. There are governments all over the world who are thinking about how they want to sort of deal with the tech giants. I mean, are there any laws in Europe or elsewhere that you think are successful in regulating tech, and would sort of importing them here be feasible? Luigi, let's start with you on that one.
I'm not so sure that there is a lot that we can learn from others. First of all, in some cases, this regulation is designed to make it more difficult for American companies to go there. So it's not necessarily the goal that we want to have. I'm not so sure that there are like brilliant examples of how things are regulated in other countries. I think we're all struggling with the novelty of the threat, and I think that since many of these platforms are located in the United States, I think that the U.S. Antitrust should take the lead in trying to change them.
Let me give a couple of examples that I think are worth looking at. I mean, I like to point to the UK and their Competitions and Markets Authority. They've had a process for several years of looking at online markets. There was several reports, and they've got a whole strategy. Andrea Koskeli, who's the head of the CMA, is really good, and the government is passing laws to empower the CMA. And what Andrea said very clearly is they're going to step in here and pass some rules, interconnection, for example. The reports are very thoughtful. They recognize the power here of these companies. They understand what's going on, and they're going to, as he says, it's experimental. They're going to try some things and see how they work. It's a regulatory authority with a lot of expertise, and they're bulking up. They're hiring a lot of people to do this, technical folks as well as economists and other people who understand the industry. So I think this is the way to go to build up a capable agency. I don't think the courts can handle these problems. Like I said, a federal judge, as they're generalist judges, it's not the right place for these things to be worked out. So that's one model. But we don't know yet how it's going to work. It's in process. I just think what they've done so far is very good. The other thing I'd point to is intriguing, which is in Australia, in order to help the journalism and local news, which we have a real concern with in this country too, of course. They've been looking at ways to basically get, I think, Facebook and Google to fund that by intervening in the business relations between the platforms and these news outlets. And Facebook and Google don't like it one bit. But I think it's an intriguing model, because what's happened to local news is a lot of the revenue has just been drained away by advertising competition. Online advertising is starting with Craigslist and classified ads, which used to be a lot of revenue. That's a real problem for our democracy. And so the Australians have a way of trying to deal with that. It's kind of a backdoor, like a taxation system. So, but it is a move. So that's just interesting to me, as a more targeted way to solve that problem about local news and journalism, which I think is a real issue.
Funny, because I'm not a big fan of the Australian model. It seems that number one is a huge boon to Murdoch, that in fact is not a coincidence that was passed in Australia, because Murdoch is very powerful and made sure to be subsidized by the big tech. And second, it seems to be exactly the opposite of what Carl was saying earlier, because if the fact that your business model destroy the way journals or newspapers are financed is not your responsibility. If newspapers are important for democracy, this should be financed through a tax, but to the public purse, but in a way that is not targeted to one particular industry. They have no responsibilities. As a Craigslist is not responsible for, it did cause the destruction of American and international newspapers, but I wouldn't tax him for that. I don't see why. This is protecting competitors rather than protecting competition.
So let me be clear, I didn't mean to endorse the Australian model. I agree with you, it would be better to fund this through general taxation. rather than in the Australian case, go after two big, profitable, powerful companies that happen to be American. Okay. And by the way, Rupert Murdoch, this is very convenient for him.
Yeah, that's exactly the point. Yeah.
Okay. So believe me, I'm not endorsing it, not at all. I'm just saying it's an example of at least trying to come up with funding for local news rather than, and recognizing that the problems for local news has been a result of competition, not the lack of competition.
Yeah, there's a similar proposal that's pending in Congress called the Journalism Competition and Preservation Act that would create a sort of limited antitrust exemption for news organizations so that they could more collectively bargain terms with Facebook and Google. It has some support, some non-support from other people. I'm going to ask Luigi and Carl one more question, but just a reminder that we're going to start taking audience questions here in a little bit, and you can submit a question using the live chat on YouTube, on Facebook, or if you go on Twitter, you can use the hashtag BPCLive. So I'd like to get back to this idea that Carl has raised a couple times now, that the courts are not actually a good place for deciding some of these questions about what is competition in this industry, just because they're a little bit slow and they're not very expert. And that's why a lot of people have been talking about the FTC. Is the FTC, though, the right agency to sort of be overseeing this? Do we need a new agency? And why don't you sort of start with that one, Carl?
Well, of course, if I were the chair of the FTC, I would be in favor of giving them lots of power. More seriously, I think we need to distinguish, when we talk about the FTC, between two functions. One is the traditional function of enforcing the antitrust laws, including the Federal Trade Commission Act, which by investigating and challenging mergers, challenging conduct, such as the case against Facebook now. That role, in general, I would like to see increased. I would like to see them have more funding. And I would like to see the antitrust law, the courts, either the courts or Congress, take action to expand what the antitrust laws can do. So that the FTC was set up in 1914 as an expert agency to do that. And I'm all for it. Okay, so that doesn't require fundamentally a change of law, although it does depend on how the courts interpret antitrust laws. So that's, let's call it antitrust enforcement. The other area is rulemaking. Acting as a regulator and passing rules, say companies can't do this, you're limited, okay? And those tend to be, those rules are not targeted at specific companies typically, they're targeted at an industry, certain practices. The FTC has long had consumer protection rules, but we're now talking about competition rules, unfair methods of competition in the lingo. And that's not something the FTC has done. Lena Khan, who's current chair, has indicated she's very interested in doing that. It's unclear whether the FTC has the statutory authority as its current Supreme Court would view it. That is unresolved. But there, I think, I'm personally in favor of the FTC getting into rulemaking in a careful way and hopefully showing that they're getting the court to confirm that they have the authority. Like I said, that's unclear. But then the question is what rules and how to do them. And specific rules such as the rule against pay for delay in pharmaceuticals would be great to go beyond what the Supreme Court said in the activist case. Broad rules about tech platforms, well, I'm going to have some of the same concerns that I raised about the litigation. This needs to be done carefully. But as I said, the courts aren't so good at it. An expert agency is a better place. So the FTC would be a place to go there. And let's see, maybe they're going to.
Luigi, what about you?
So I'm a little bit surprised that Carl is so negative on judges because the University of Chicago and the University of Berkeley together, and I think he participated for many years, have taught judges antitrust and what to do. So if he has lost hope after all that teaching that the judges are any good, I think that's pretty scary. I have to say that not having the expertise of Carl and knowing how good or bad the judges are, my knee-jerk reaction is actually to favor the judiciary over the technical agency, and even more so the special courts. And I have to say, for two very simple reasons. One is my Italian background, and in Italy, special courts were introduced by the fascists and were terrible. And so every time I hear special courts, I am concerned. But more to the point of today's economy is when you have a very specialized court, the risk of capture is very, very strong. And we know that in intellectual property right decisions, we see a lot of capture by basically the pharmaceutical industry, because the very experts that are appointed to judge, then they become IP lawyers and so on and so forth. So my fear that you put it to a technical agency to the point that you lose visibility and you are completely in the hands of the industry itself is a real issue. I think that Parliament, Congress should actually legislate more, and so that makes it clear what to do, and then let it be done by the judges. After all, the system is not that the judge should be an expert in everything. They decide on very complicated cases of a lot of things, including forensic evidence, etc. And I think that their secret is that they try to be impartial, and the role of expert, like the one that Carl plays, is really to educate them, and but let somebody independent take the final decision, and not somebody that steps down and the next day works for the very same people that had to be judged.
Well, let me respond to that. First, since I have testified quite a few times in federal court, I don't want to be seen as being negative on judges. That's actually not my view, either retrospectively or prospectively appearing in front of judges in the future. My point is, it's just institutional capability. There's a lot of technical issues, and a judge could appoint a special master. There's things judges could do. It's just it becomes more technical. There's a reason we have regulatory agencies to do these things, and Congress, they're going to pass some general rule about non-discrimination or unfair competition. There's just a huge amount of running room there. I just think there's a role for expert agencies. So again, it's just institutional capabilities, Luigi. The other thing is capture. I totally agree with you. I'm very concerned about capture. I've seen it in many sectors when I was at DOJ. But one of the things that's good about DOJ, Antitrust, and FTC, their competition, is they're not specific to an industry. And it makes it harder to capture. Okay, I don't think the Antitrust Division has often been captured. There's been political influences sometimes that I'd rather not get into. But so my thought for the FTC, if it's the FTC, would be if they're doing generalized rules, they would be less subject to capture. But I'm concerned actually right now, for example, that companies who don't want to face competition from the big tech companies are going to have undue influence at the FTC in just the sort of capture way that you're talking about. So I take your point that agencies are more subject to capture than the courts, which we hope and think of as more insulated. So I accept that point. It's a real challenge, but sometimes you just have to take risks, like you were telling us earlier, Luigi.
That's absolutely right. But let me ask a question. This is not a tricky question. I really want to know, because I know that you have testified on both sides of the equation. So it's not like you have only experienced the plaintiff side or the defendant side. You have experienced both. So can you say that on average, there is equal amount of money on both sides, in that you can make as much money defending companies in antitrust cases as you can make attacking companies in antitrust cases?
Well, first off, I think all of my testimony in court over the past 15 years, 20 years has been for plaintiffs in antitrust cases, almost all government actually. Just I'm kind of unusual in that respect because let's say so I think for the lawyer, look, I'm concerned in the merger area. Let's give an example. There's a huge amount of money. Companies, look, investment bankers, deals, there's a huge amount of a whole economy, if you will, surrounding deal making. And, there's trillions of dollars of deals and they need to be, okay. And that trickles down in antitrust. There's hugely more money spent by companies who are seeking to merge than either the government investigating them or companies trying to stop mergers, which happens, sometimes that happens. So if you're just asking about resources, it's wildly imbalanced. It's one reason I favor increased funding to the FTC and the DOJ antitrust division, but it's never going to equal that. I mean, I could tell you, for example, when I testified for the DOJ in the AT&T Time Warner case, I know from multiple sources, AT&T spent a lot more money than the government could possibly have devoted to that case. And that's typical in these cases. That's the nature, it's a challenge, okay, in terms of having the fair administration of the antitrust laws, in my view.
Great. So we're going to turn now to start asking some audience questions. Our first audience question is from Babu Jackson. Can the negative externalities associated with Facebook's impact on teenagers, et cetera, be quantified in terms of monetary costs and applied to the consumer welfare standard?
Let me try that. I'm sure that Carl will correct me, but I think that this is very little to do with the consumer welfare standard. This is a behavior that damages consumers. So if I am a casino company and I target people with addiction to come and gamble in my casino, I make a disastrous thing. I damage consumers in a major way. That has very little to do with competition. So I think that there is a problem of consumer harm, but not every consumer harm is a competition problem.
Carl?
So I'm going to mostly agree. Let me pick up on it, which is, look, anytime we have a product that is causing harms, if it's large harms, we'd like to stop it and in some cases measure the harms so that we can see that, make sure the problem's big and worthy of a response and possibly impose liability, whether it's tobacco, whether it's pollutants, whether it's, an addictive drug, whatever. And, that to the extent that Facebook is causing these harms, I guess you asked about teenagers in particularly, I think it's very valuable to measure the extent of it. I'm not sure I'd measure it in dollars. I mean, I'm really thinking more about human lives and people's lives than dollars. I don't feel the need to turn it into dollars necessarily. Yes, the economist said that, surprise. But that's to recognize the problem, and then that does. But it's not really the consumer welfare standard in competition, because the inherent problem here is Facebook, their financial incentives have been to do this damage. And that's what needs to be corrected. So they don't have financial incentives to do this anymore. And it's not a competition problem, it's an underlying incentive problem.
Our next question is from Hannity Jordan. Do you think that the Facebook revelations need to be addressed separate from the other big tech issues?
I would say absolutely. And look, it's very common to lump together the big four, right? Apple, Amazon, Facebook, and Google. Maybe people throw in Microsoft. I guess those would be the 5 companies, so far as I know, who would be covered platforms under the proposed legislation. But it's so different. Everything's so different, it just, and so, and then Facebook in particular is toxic. So, look, so it needs to be handled separately. To the extent there's other platforms, you could worry about YouTube and content moderation too, because that's really big. Twitter, any social media platform, TikTok, but that's completely different than what's going on Amazon or Google search for that matter. Those are just different. And if you lump them together, you're just gonna get the wrong solutions, because it's just different problems.
I agree completely with Carl. I, however, would like to warn of a risk. My fear is that there is, at least in certain environments, an attempt to decide we want to basically introduce censorship, not by the government that cannot do it, but we're going to force a private entity to do censorship for us, where we decide what is legit and we decide what's not legit. So is not legit, at least was not legit, to discuss the theory of where the COVID was coming from. And for a while, you couldn't actually talk about this in Facebook. And then it turns out that even the Biden administration started to raise the issue. And then, of course, there was a change. So I think that the risk of censorship is real. And with all the negative I want to say about Facebook, I don't want this to be simply a way to force Facebook to introduce a censorship indirectly.
So, censorship is a strong word, and we have the First Amendment in this country particularly applies. So I guess it feels to me like the solution for some of this is a liability regime, which is not a censorship regime, but where this would involve changing Section 230, right? So that there would be liability for reckless disregard for the truth, or blocking content that was valid content. So pick up on both parts of Section 230. I don't think that's censorship at all, and I don't see any reason why we can't have liability for propagating lies.
No, I completely agree with you. I think that, however, my understanding is private companies can do whatever they want. So Facebook could decide not to post news by Italian Americans. I guess it's not a race, so it's not a race, it's not a religion. So I think that they probably can. And my fear is that the government, whoever government is in power, because at the end of the day, Facebook is going to always side with the government in power. Whatever the government in power uses Facebook, and by the way, not only in the United States, but you go to Turkey, you go to India, they face with the government in power to decide what is acceptable and what is not acceptable.
I don't think the Italian American thing would work because ethnicities are covered. But here's another question from Anna Fridley. Is there a national security concern if big tech is broken up?
No.
That's not the basis of breaking these companies up in some sort of fit of pique is not a good idea, period. I don't know that I would rely on a national security argument to get there. There is a national champion argument. It's a little bit different, which competition people don't tend to like either. But to me, it just comes down to what do we want to do to promote competition, and breaking up these companies, some sort of broad brush way is not going to do that.
Piece of advice that you wanted to give to Congress or the DOJ and FTC as they're sort of considering these issues right now, what would it be? We'll start with you, Luigi.
I think that just to do something, it seems that there are many laws that have been proposed, going from the most benign, which is to increase the mergers fee so that actually they can hire more people to review the mergers. That seems like a no-brainer. If the Congress cannot pass even that law, it seems like crazy. Two more sophisticated, like favoring interoperability or stop discrimination on the platform. I think that there has been a time of discussion and proposal. I think now is the time of acting. And I think that if this Congress cannot deliver anything on that margin, would be a major disappointment.
Well, I think I would say two things. One is that the agencies should vigorously pursue in a principled way the cases they brought against Google and Facebook. Those are the big things. Those are, unfortunately, neither is going to trial for like a couple more years, as far as I can tell. And that's a problem to me in terms of the public's perception of antitrust as being slow. But they should pursue these vigorously, like I said, in a principled way. That would be one thing, because that's, those are so visible right now. The other thing I would say would be to have vigorous antitrust enforcement following sound economic principles. And I've written a lot about how to do this, but it does not involve rejecting the case law of the last 40 years. It does not involve rejecting economics. It does not involve a big is bad philosophy. And I don't think Merrick Garland is going to want to do any of those things, any of those things that I'm advising against. So there's a way to smartly proceed to have vigorous and effective antitrust enforcement. And that's what I would urge.
So the next question is from Nick Gondek. Is there any advantage or disadvantage to states passing their own laws on privacy or algorithmic fairness or things like that to address big tech issues outside of antitrust enforcement?
So I think it depends a lot on which state it is, because I think if you're California, you're very influential. With all due respect, if you're North Dakota, much less so. So there's a bit of a challenge there. But I think that it is interesting, and this is one of the advantages of the federal system in the United States, that there is this flexibility of trying with different strategies in different states and see what happens. Now, the problem is that for many of these algorithms, either the companies adapt and then they adapt everywhere, or they adapt nowhere. So we end up being regulated by the GDPR, even if the GDPR is in Europe, because once that you set up the system to adapt, it's very difficult to opt out. So I think there is this risk that there are big externalities in the legislation, and we have to be careful about that.
Well, speaking from California, and I have a background from UC Berkeley behind me, that's Sproul Plaza. I am proud of California often leading the way, including such things as auto emissions standards. So I think there's something to be said for that, and there's been some movement there on privacy as well. I get nervous if there's balkanization, between different parts of the country. But yes, there's things some states can do. California has been a leader in that, and I'm proud of it.
We are out of audience questions, so I'm going back to my questions. Carl, there's been a lot of discussion about how some of the proposed legislation, particularly the stuff focused on mergers by the big tech companies, will impact venture capital. What are your thoughts on how venture capital might be impacted by these laws? And is that a bad thing?
Well, right. So first, venture capital is booming these days. It's twice what it was last year. I mean, it's quite the boom, even very frothy, I would say, based on the data. So right now, that's just the state of play. But I don't, when you ask me, I favored tightening up antitrust law so that if a dominant firm tries to buy a potential competitor, that it's easier for the government to stop it. Okay, and the Facebook acquisitions of Instagram and WhatsApp are kind of poster children now for this, with the FTC challenging that, in the current case. But there are many other examples. So if that were tightened up, I'm not, my issue, what I think we should be thinking about for antitrust is, would that help promote competition and preserve threats to these big companies, these powerful companies? That is a valuable part of competition and innovation. And that would be the goal. If that pissed off some venture capitalists, I don't think that should be the criteria. Okay, it's really, what about innovation and serving customers in the long run? I should say though that kind of crude, I'll call them, methods to say, the big tech companies shouldn't be allowed to buy anybody anymore. that would be just sort of dumb as far as I'm concerned. If you look at the acquisitions they've made over the years, and the FTC just came out with a report looking at the acquisitions of the big four companies, 4 or 5 companies over a decade or so, you can see that many of them, they're tucking in, they're acqui-hires, they're adding capabilities. They're using these small acquisitions to go after other companies, including other big tech companies. So it's a very healthy part of, most of these acquisitions are a healthy part of the competitive process. A minority are suspicious, let's say, or downright bad. And that's what I would try to tune things, move the line to give the government a strong ability to stop those. But it's, in the end, it's a relatively small fraction of their acquisitions. So, and I don't think that's going to really harm venture capital. I mean, look, that's that, and if it did, in a limited way, that's worth it if it's promoting competition. Okay, but VC is doing very well right now, and I don't think the type of proposal I'm talking about would really put a dent in that, but it would be beneficial.
So thank you guys so much. We are at our time for this event. Thank you all for joining us at the Bipartisan Policy Center, and we will see you next time.
Thank you very much. It was a pleasure. Bye-bye.